She had lived in that house for 31 years. She had painted its shutters twice, replaced the back porch boards after the hurricane of 2004, planted the magnolia tree in the side yard the spring after her youngest was born. She knew which step on the staircase creaked at night. She knew the exact angle the afternoon light hit the kitchen window in October, and how it made the whole room look like something out of a painting that nobody rich enough to own it had ever bothered to make. She knew this house the way a woman knows her own hands. And on a Tuesday morning in late September, a man she had not spoken to in 4 years walked up her front porch steps, knocked twice, and handed her an envelope from an attorney's office in downtown Savannah. He did not say hello. He said, "You have 30 days, Naomi." Her name came out of his mouth like something he had already decided to discard. The envelope was cream-colored, heavy, the kind of paper that cost money. The kind that law offices ordered in bulk because they sent a lot of letters that changed people's lives, and they wanted the stationery to match the gravity. She did not open it at the door. She took it inside, set it on the kitchen table, and stood at the window for a moment, watching Roland Calhoun walk back down her front path to his car, a silver sedan, new, probably leased, and pull away from the curb without looking back. Then she put the kettle on. Because that is the kind of woman Naomi Calhoun Price was. She did not collapse at the kitchen table. She did not call anyone screaming. She did not pace or wail or press her back against the refrigerator and slide to the floor the way women in movies do when something catastrophic arrives in cream-colored envelopes. She made herself a cup of tea, sat down at the table she had eaten 10,000 meals at, and opened the envelope with a butter knife, and she read every word. What did that letter say about a woman who had given her whole life to a house? What does it mean when a piece of paper has more power than 3 decades of presence? And how does a family that once sat together at a Sunday dinner table end up on opposite sides of a legal document? If this story has already touched your heart, subscribe now, hit like, and tell me in the comments what city you're watching from. Remember, this is a dramatized fictional story for entertainment only. It does not provide legal, medical, or financial advice. Viewer discretion is advised. Keep watching until the very end, because at minute 15, you'll get a major reveal. Naomi Josephine Calhoun Price was born in Beaufort, South Carolina, the second of 3 daughters raised by a mother who cleaned houses for a living and a father who drove long-haul freight and came home smelling like highway and diesel and something that was almost peace. She had not been handed anything. She had earned her teaching certificate at age 22, her principal's credential at 34, her master's degree she finished at night while raising 2 children and working full-time, her textbooks spread across this very kitchen table, a cup of cold coffee at her elbow, and the sound of Savannah sleeping outside the window. She had married Edmund Price at 26. Edmund, who was warm and funny, and a little careless with money in ways that had sometimes frightened her, but who loved her with a consistency she had never doubted. Edmund, who had inherited this house from his mother, Geraldine Price, who had inherited it from her mother before that. A 4-bedroom Victorian on Abercorn Street, built in 1901, sitting on a corner lot under 2 massive live oaks that had been there longer than anyone could remember. The house had a name, the way old Savannah homes sometimes did. People called it the Price House, not because it had a plaque or because anyone had officially named it, but because the Prices had lived there for 4 generations, and in a neighborhood with a long memory. That was enough. Edmund died 6 years ago. A stroke, quiet and sudden, on a Sunday afternoon in June while he was reading on the back porch. He had not suffered. He had not had time to be afraid. What he had also not had time to do was update his will. He had a will. That much was true. He had drafted it in 2009 after the birth of their youngest child with a Savannah attorney named Gerald Fitch, who had since retired. And the will said, in language that had seemed perfectly clear in 2009, that the house and its contents would pass to Edmund's wife, Naomi, and thereafter to their children equally. What the will did not account for was a 2003 legal instrument that Edmund's mother, Geraldine, had created before her death, a living trust drafted with a different attorney, never fully dissolved, never fully transferred, that still carried a reversionary clause that named as secondary beneficiary in the event of certain conditions, Edmund's brother, Roland Calhoun, not Roland Price, Roland Calhoun. Edmund had taken his mother's name when he married. Roland had kept the family name. They were half-brothers, technically, raised in the same house, never close, connected mostly by obligation and the gravitational pull of the family property. Roland was 63 years old. He had lived in Atlanta for most of his adult life. He had money, not a great deal, but enough, and 2 ex-wives and a son he rarely spoke to, and a very particular understanding of what he was owed by the world. He had always believed that house should have come to him. Geraldine had not thought so. Edmund had not thought so. But Geraldine was gone, and Edmund was gone. And now it was just Naomi, and a reversionary clause, and a letter from an attorney who had found the old trust through a routine probate search triggered by Edmund's estate filing. The letter said that based on the conditions outlined in the 1997 trust document, specifically, that the primary beneficiary must survive the grantor by a period of no less than 20 years and must maintain the property free of debt encumbrance for a period of no less than 5 consecutive years. The reversionary clause had potentially been activated. Edmund had died in 2019. He had survived Geraldine, who died in 2015, by only 4 years, not 20. And the mortgage. There was still a mortgage on the house. Edmund had refinanced in 2014, taking out a home equity line to cover some medical bills and a small business loan for a venture that had not worked out. The loan was still carrying a balance. Not large, but present. Potentially present enough. Roland's attorney, a sharp, quiet man named Haverfield, based in a mahogany-paneled office on Bull Street, had filed a petition with the Chatham County Probate Court, arguing that the reversionary clause had been triggered, and that the house should revert to Roland Calhoun as secondary beneficiary under the original trust. 30 days, Naomi. 30 days to respond, retain counsel, and demonstrate either that the conditions had not been met or that the trust had been superseded by Edmund's later will. She set the letter down on the table. She pressed her palms flat against the wood. Then she looked around her kitchen, at the yellow curtains she had sewn herself in 2011, at the cast-iron skillet hanging on the wall that had belonged to Geraldine, at the small framed photograph on the windowsill, her and Edmund at their youngest daughter's college graduation, standing in the sun, squinting and laughing. She did not cry, but she sat with it. She let the weight of it sit with her, the way a woman who has survived difficult things learns to do, not pushing it away, not letting it flatten her, but acknowledging it fully before deciding what to do next. Outside, the September light was golden and still. The kettle began to whistle. That same afternoon, the calls started. Not from Roland. Roland had delivered his message through paper, the way people who believed in procedure always did. The calls came from her children. They arrived in a specific order that told Naomi everything she needed to know about the state of her family. Marcus called first. Marcus was 33 and worked as a financial analyst in Charlotte. He was her oldest, and he operated the way oldest children often do when they have watched their parents work themselves down to the bone, with a ferocious practicality that sometimes looked, to the untrained eye, like coldness. He was not cold. He was armored. There was a difference, though he himself had not always been able to see it. "Mom." His voice was already moving when she answered. "I just got off the phone with Aunt Diane. She said Uncle Roland served you papers." "He did. Today. This morning." A pause, the sound of him standing up from whatever desk he had been sitting at. "Tell me what the letter says." She told him. All of it. She had already made notes in the margin of the letter in pencil, the way she used to annotate students' essays, bracketing the clauses she didn't understand and underlining the ones she did. He was quiet through all of it. Then, the trust predates the will. That's the problem. That appears to be the argument. "We need an estate attorney, not Fitch. He's retired, someone who handles trust litigation." "I know. I can come down this weekend." "I know that too." Another pause. She could hear him thinking. "Mom, how much is left on the equity line?" There it was, the question beneath the question. She had known he would get there. $42,000, she said. Silence. "Edmund took it out in 2014, she said. "We paid down a good portion. There's 42 left. And the conditions in the trust require the property to be debt-free for 5 consecutive years." Yes, she heard him exhale, not dramatically, just the sound of a man calculating something he did not like the answer to. "Okay," he said. "Okay, I'll look into attorneys tonight. I'll call you tomorrow. Marcus, yeah, I'm all right. He did not say he knew that. He said, I'll call you tomorrow, and hung up. Simone called an hour later. Simone was 31, the second child, and she was nothing like her brother. Where Marcus processed the world through spreadsheets and contingency plans, Simone processed it through fire. She was a community organizer in Atlanta, deeply principled, profoundly impatient, and constitutionally incapable of pretending that wrong things were acceptable. Tell me you're not going to let this happen, was how she opened the call. Hello, Simone. Mama, tell me. I am going to respond appropriately through legal channels. That man has been waiting for Daddy to die so he could make a move. You know that. We've always known that. We suspected it. Same thing. It is not the same thing. Simone made a sound that was somewhere between a laugh and a groan. He served you papers, Mama. On a Tuesday. Without warning. You've lived in that house for 30 years. 31. 31 years, and he walks up and hands you an envelope like you're a stranger. Naomi looked at the envelope, still on the table. He was never comfortable calling me family. That's his failure. It is, but it's also now my legal problem. Simone was quiet for a moment. Then, I'm coming home. You don't need to. I'm coming home, Mama. The call ended. Darius called at 7 that evening, and his call was the shortest and the hardest. Darius was 28, the third child. He had gone through a period in his early 20s that the family spoke of carefully, obliquely, a period of depression so quiet and so deep that it had looked, from the outside, like simply being withdrawn, until the day Naomi had found him sitting in his car in the driveway at 2 a.m, keys in the ignition, not going anywhere, not coming inside, just sitting in the dark like a man who had forgotten there were other options. He had gotten help. He had stabilized. He worked now as a librarian in Savannah, in the same city as his mother, and he came for dinner on Sunday evenings and rarely said much, but he was present, and presence, Naomi had learned, was its own form of recovery. Is the house going to be okay? He asked when she answered. I'm working on it. Because if you need to leave it, if it came to that, he stopped, recalibrated. You can live with me. I just want you to know that. Her throat tightened in a way she did not let reach her voice. I know, baby. I mean it. I know you do. Okay. A pause. I'll come by tomorrow. I'll make dinner. Okay. He hung up. Her youngest called at 9:30. Celeste was 26 and was in her second year of law school at Emory. She was the one who had inherited Naomi's composure and Edmund's warmth in equal measure, and she called the way a second-year law student calls her mother when she has already done 30 minutes of research. The reversionary clause is a real problem, she said without preamble, especially if Haverfield argues that the will was intended to govern personal property, but the trust governs real property separately. The question is whether the trust was ever formally extinguished. And was it? I don't know yet. That's what I'm trying to find out. I need to see the actual trust documents. Do you have them? No. Edmund handled the estate filings. Everything is with Gerald Fitch's old office. Do you have the file boxes from after Daddy died? In the study. Yes. Go through them tonight. Look for anything that mentions the 1997 trust, any amendment, any dissolution document, any correspondence between Daddy and Fitch that references Grandma Geraldine's trust. Anything. Naomi was already walking toward the study. Celeste. Yes, ma'am? You are going to be a very good attorney. A brief quiet, and then Celeste said, Don't thank me yet. Go find the documents. Naomi went to find the documents. She was in the study until midnight. She did not find a dissolution document. She did not find an amendment. What she found, in a manila folder at the bottom of the third box, was a letter, handwritten in Edmund's slightly messy cursive, that he had apparently started but never sent to Gerald Fitch, dated March of 2018, 18 months before his death. It read, in part, Jerry, I need to talk to you about Mother's trust. I think there's something in the old document that could cause problems down the line. I keep meaning to call. I'll call this week. He had never called. The letter sat in her hand, in the quiet of the study, under the lamp that still had the same shade Geraldine had picked out in 1992. Edmund had known. He had seen it coming. He had meant to fix it. He had run out of time. Naomi set the letter down on the desk. Outside, the first suggestion of autumn rain began tapping against the study window. The person who had been living in the carriage house behind the Price property for the past 14 months was a woman named Pearl Okafor. Pearl was 44 years old. She had come to Savannah from Columbus, Ohio, after a divorce that had left her with her dignity, her furniture, a 10-year-old Subaru, and a skill set that did not have an obvious job title. She had worked as a paralegal for 9 years, then as an office manager for a small real estate firm, then as a caregiver for her own mother, who had died of Alzheimer's 18 months before the divorce. During the caregiving years, she had also taken online courses in estate documentation, records management, and property research, the kind of skills you develop when you are trying to make sense of a parent's finances during a crisis, and nobody around you knows what they're doing. She had found the carriage house listing on a rental site. Naomi had posted it after Edmund's death. A small income, a practical arrangement, some company on the property without the intimacy of sharing a house. Pearl had sent a clean, professional inquiry. Naomi had been impressed enough to invite her for a conversation. Pearl had arrived with her references organized in a folder and had asked, before sitting down, whether she could leave her shoes at the door. Naomi had liked her immediately. Pearl mowed the property's side lawn. She helped manage deliveries when Naomi was at work. She drove Darius to doctor's appointments twice when he had gone through a rough patch the previous winter and hadn't felt safe behind the wheel. She had never asked for anything beyond her rental arrangement and the occasional glass of sweet tea on the back porch. She did not know about the letter from Roland's attorney. Not yet. She found out the next morning, the way people find out about things in small domestic orbits. Not through a conversation, but through evidence. She came to the main house at 7:30 to return a casserole dish she had borrowed, knocked on the back door, and found Naomi at the kitchen table, surrounded by open file boxes, the cream-colored envelope flattened on the table, the unsent letter from Edmund in a clear plastic sleeve beside it, and a yellow legal pad covered in notes. Naomi looked up. Pearl looked at the table. "Should I leave the dish and go?" Pearl asked. "Sit down," Naomi said. "I was going to ask for your help anyway. I just hadn't gotten there yet." Pearl sat. Naomi told her. All of it. Cleanly, without performance, the way she had told Marcus on the phone. Facts, sequence, relevant clauses, unknowns. Pearl listened without interrupting, which Naomi noticed and appreciated. When Naomi finished, Pearl sat quietly for a moment. Then she said, "Do you have access to the Chatham County Probate Court online records portal?" "I can get access." "Good. The petition will be public record. I can pull the exact filing language and we can see what Haverfield actually argued. The language matters, because if he argued the conditions were triggered by the equity line, we need to know whether he cited the current balance or the original principle, and whether he addressed the question of Edmund's will at all in his filing." Naomi looked at her. "You know probate law." "I know probate records," Pearl said carefully. "I'm not an attorney, but I know what the documents look like, and I know how to read them. And I know which questions to ask a real attorney to make your consultation hour actually count." A small silence. "Your consultation is probably going to cost you $400 an hour," Pearl added. "You don't want to spend the first half of it explaining what a reversionary clause is." Naomi nodded slowly. "Pull the filing." Pearl pulled out her phone and began. The next 3 days moved the way crises always move when you are in the middle of them, both too fast and too slowly, time behaving strangely, the ordinary world continuing to exist in a way that feels slightly insulting. The mail still came. The neighbors still walked their dogs. The September heat still pressed against the city's old stones with its particular Savannah insistence. And inside the Price house, the family began to gather. Marcus arrived Saturday morning in his slate gray car, pulling into the driveway with the careful precision of a man who had driven 8 hours and was conserving his composure for what lay ahead. He stood in the front yard for a moment looking at the house, at the porch, the live oaks, the second-floor window of his childhood bedroom, and something passed across his face that was gone before he let himself in through the front door. He embraced his mother in the kitchen, brief, firm. He looked at the file boxes on the table. "Pearl pulled the probate filing," Naomi told him. He blinked. "The tenant? She has a background in records and estate documentation." He processed this. "What does the filing say?" "That the trust was never formally dissolved, that the equity line constitutes a debt encumbrance, and that Edmund died before the 20-year survivor clause had elapsed." Marcus sat down. He had already known most of this from his own research, but hearing it stated plainly seemed to recalibrate something in him. Haverfield is good, he said. I looked him up. He's done 12 successful trust reversion cases in the past 8 years. I know, Naomi said. His win rate… Marcus. He stopped. I know who Haverfield is, she said quietly. I know what we're facing. I need you to help me, not brief me. He held her gaze for a moment, then nodded. Once. Okay, he said. What do you need? Simone arrived that afternoon in a rental car, sunglasses on, jaw set, wearing a t-shirt that said, Organize in small letters across the chest. She was thinner than the last time Naomi had seen her, the way people get thin when they care too much about too many things at once and forget to eat. She came in through the front door and went straight to the kitchen, straight to the boxes, straight to the yellow legal pad. Tell me where we are, she said. Marcus told her. She listened with her arms crossed, not looking at him, looking at the wall behind his head the way she did when she was processing information quickly. Then she said, Roland filed this 2 weeks ago, and we're only finding out now? The petition was filed September 9th, Naomi said. He served me the letter personally on the 23rd. 2 weeks. Simone's voice was flat and sharp, the way a blade is flat and sharp. He let 2 weeks of our 30-day window expire before he even told you. The room was quiet. That was intentional, Marcus said. Of course it was intentional. Simone finally uncrossed her arms. He calculated exactly how much time to take without giving us enough to fully prepare. He knows probate timelines. She looked at her mother. He's been planning this. I believe he has, Naomi said. But we respond to what is, not to what was planned. Darius arrived Sunday evening, quiet and steady, and helped Naomi make dinner for the family, the first time all 4 of her children had eaten at this table in 2 years. He stood at the stove and stirred the pot and did not say much, but his presence in the kitchen had a quality of stability that Naomi found, that night, to be the most comforting thing in the room. Celeste drove up from Atlanta the following weekend, armed with casebooks and printed statutes and the names of 3 trust litigation attorneys she had identified through her law school's alumni network. She brought Pearl into the conversation directly. You pulled the Haverfield filing, she said to Pearl, who was at the kitchen table with her laptop. What's your read on the weakest point in his argument? Pearl looked up, slightly surprised at the directness. Then she said, he doesn't address whether the equity line's balance at the time of Edmund's death constitutes an encumbrance in the way the trust language intended. The trust language says, free of debt, encumbrance. Edmund drew the line in 2014. He paid it down significantly. The question is whether the intent was to preclude any remaining balance, or specifically to preclude the kind of leveraged debt that risks the property. Celeste nodded. Ambiguity in the instrument. That's my lay read. That's also the first thing I'm raising with the attorney. Celeste looked at her mother. This is where we start. Naomi watched her youngest daughter, 26 years old, law books on the table, jaw set, voice steady, and felt something expand in her chest that she could not name precisely. Not pride, only. Something older and more complicated. The sense of recognizing someone. The sense of knowing, looking at Celeste, that this woman had been built from something that could not be easily taken. The attorney they retained was named Audrey Simmons Holt. She had practiced estate and trust litigation in Savannah for 22 years. She was methodical, plain-spoken, and had a quality that Naomi had come to associate with people who had seen many bad situations. She was not surprised by anything, and she was not afraid of anything, and her calm was not the calm of someone who did not understand the stakes. It was the calm of someone who understood them completely and had decided to be useful anyway. She reviewed the documents over 2 days. Then she sat with Naomi and Marcus at the kitchen table and laid out the landscape. The trust exists, she said. It was never formally dissolved. That's the baseline problem. Edmund's 2009 will almost certainly governs his personal estate, but Geraldine's trust governs the real property separately. And there is a genuine legal question about whether the will superseded the trust's reversion provision. What's the answer? Marcus asked. The answer is that it depends on Georgia probate case law, the specific language of both documents, and which judge we draw. She folded her hands. I want to be honest with you. This is not an open and shut case in your favor. Haverfield found a real thread to pull. Naomi was quiet. However, Audrey said, There are 3 points in your favor that I intend to argue aggressively. First, the ambiguity in the encumbrance clause Pearl identified. I think that's legitimate, and I think a judge could reasonably interpret debt encumbrance in the context of the 1997 trust to mean leveraged debt that places the property at risk, not a small equity balance on a property that has significantly appreciated. Second, there is a question of whether Roland has standing to file under this specific reversionary clause, given that the trust named him as secondary beneficiary to Edmund, not to Naomi, meaning his rights under the trust may not have been triggered by Edmund's death alone, but only under additional conditions that may not have been met. And the third? Naomi asked. Audrey looked at her. The third is you. You have lived in this property for 31 years. You have maintained it. You have paid its taxes. You are its practical and moral owner. That is not a legal argument by itself, but equitable considerations exist in Georgia trust law, and I intend to make the court feel the weight of what is being asked here. Naomi held her gaze. How much? To take this through hearing. $10,000 to $15,000, depending on how contested Haverfield makes it. Marcus opened his mouth. I have it, Naomi said quietly. She had been saving for years. The way women who had grown up with nothing always saved, carefully, consistently, not trusting that safety was permanent. She had a savings account that Marcus did not know about, that nobody knew about really, except her and the bank. Edmund had always called it her rainy day fund. He had not known how right he was. Marcus closed his mouth. Audrey nodded. Then we file our response this week. On a Wednesday morning, 11 days after Roland's letter arrived, Pearl was at the Chatham County Records Office pulling copies of the original 1997 trust instrument when she ran into something that stopped her. She was not supposed to be there, technically. She was not an attorney, and she was not officially retained by anyone. But she had a general access request from Naomi in her pocket, and the records clerk had processed it without comment, and Pearl had spent 3 hours in the archive room with a scanner and a notepad. What she found, in the supplemental file attached to Geraldine's trust, was an amendment, dated 2001. It was a single page, handwritten on legal paper, signed by Geraldine Price in her unmistakable careful cursive, witnessed by 2 signatures Pearl did not recognize, and notarized with a faded stamp. The amendment read, I hereby modify Section 4C of the Price Family Revocable Trust of 1997 to clarify that the secondary beneficiary designation shall apply only in the event that the primary beneficiary and their spouse die without surviving issue or without a valid testamentary instrument that specifically references and supersedes this trust. Without surviving issue. Edmund had 4 children. Surviving issue. Pearl sat very still in the archive room for approximately 45 seconds. Then she picked up her phone and called Naomi. Naomi answered on the second ring. Pearl. Mrs. Price, Pearl said carefully. I think you need to come down to the records office. I found something. Naomi was there within the hour. She stood beside Pearl at the archive table and read the amendment twice. Then she read it a 3rd time, slowly, her finger tracing each line. Then she said, This was here the whole time. Filed in the supplemental annex to the original trust, Pearl said. Not in the primary file. Haverfield may not have found it, or he may have found it and chosen not to disclose it. The implication of the second possibility hung in the air between them. He is an officer of the court, Naomi said. Yes, which means if he found it and didn't disclose it, that would be a significant problem for him. Pearl kept her voice neutral. But we don't know yet which it is. Naomi looked at the amendment again. Edmund had 4 children when Geraldine died in 2015. He clearly had surviving issue. Even if he didn't survive the 20-year clause, the secondary beneficiary designation under this amendment would not apply. That's my lay reading. Naomi looked at Pearl, not with surprise. She was past surprise about Pearl's competence, with something closer to recognition. Get a certified copy, she said. Pearl had already flagged the clerk. Audrey Simmons Holt, when presented with the certified copy of the 2001 amendment that afternoon, was quiet for a long time. Then she said, Well, she read it again. Then, This changes the landscape substantially. Does it end the case? Celeste asked. She had driven back from Atlanta when Pearl called. It significantly weakens Roland's standing argument, Audrey said. Edmund had surviving issue. Under this amendment, the secondary beneficiary clause does not apply. Haverfield either missed this or he didn't miss it, Simone said from the corner of the room, where she had been standing with her arms crossed since the meeting started. Everyone looked at her. He's been Roland's attorney for years, she said. Roland knows this family. Roland knew his mother wrote this amendment. He was at Geraldine's house in 2001. I remember him being there. She looked at her mother. He banked on us not finding it. The room held that for a moment. Audrey tapped the document. I'm filing a supplemental response on Friday, and I'm also going to raise, carefully, the question of whether the original filing constituted a complete and accurate representation of the trust record. She paused. I will be measured in how I raise that question. Can you be less measured? Simone asked. I can be measured, Audrey said firmly, because the goal is to win the case, not to destroy a man in a way that gives him grounds to appeal. Measured precision will accomplish more. Simone's jaw tightened, but she nodded. Naomi had not spoken since Audrey said, well, she was looking at the certified copy of the amendment, at her mother-in-law's careful cursive. Geraldine had written this in 2001. Geraldine, who had given Naomi the cast-iron skillet that still hung on the kitchen wall. Geraldine, who had said to Naomi at Edmund's wedding, taking her hands, "You are what I always hoped he would find." Geraldine, who had seen Roland clearly, who had always seen Roland clearly, and who had, in her methodical way, tried to protect the house. She had tried. The amendment existed, and for 14 years it had been sitting in the supplemental annex of a probate file, waiting to be found. The rain had started again outside the window of Audrey's office, soft and steady, old city rain, the kind that made Savannah's streets go dark and reflective and beautiful. Naomi set the document down. File it Friday, she said. The days between Friday's filing and the preliminary hearing had a particular quality of suspended tension, the kind that settles into the bones of a house when everyone inside it is waiting for something. Pearl, for her part, continued her ordinary routines with a care that was itself a kind of discipline. She mowed the lawn. She organized the back porch. She drove Darius to a pharmacy run on Thursday because he had mentioned his prescription needed filling, and she was going that way regardless. On the drive back, Darius was quiet in the passenger seat for most of the trip. Then he said, "Can I ask you something?" "Of course. Why are you doing all of this?" He turned to look at her. He was soft-faced, gentle-eyed, the kind of man whose sadness was always visible just beneath the surface, and who had learned, over years, to carry it without apology. "The records, the research, you're not getting paid extra. You're not family." Pearl drove for a moment before answering. "Your mother treated me like a person," she said. "The day I came to look at the carriage house, she shook my hand, and she asked me a real question, and she listened to the answer. That sounds small, but—" She paused. "It isn't, actually." Darius looked back at the road. "People like your Uncle Roland," Pearl continued carefully, "move through the world assuming that property belongs to whoever has the right documents at the right moment. People like your mother understand that property is the accumulated proof of someone's life. Those are two completely different philosophies." She signaled and turned onto Abercorn Street. "I know which one I think is right." The car pulled to the curb in front of the Price house. They sat for a moment in the driveway's quiet. "She's going to win this," Darius said. It was not quite a question. "I think so," Pearl said. "But even if she does—" He stopped. "What?" He shook his head slightly. He came to her door. He walked up her front steps. He handed her that letter like she was a tenant. He looked at the house. "She'll never not know that he did that." Pearl was quiet. "Some things you can win legally and still carry," he said. "You know what I mean?" She looked at the house too. "Yes," she said. "I do." The porch light was on. 1 week before the preliminary hearing, Roland called. Naomi was in the kitchen when her phone rang, and she saw the name on the screen. She stood there for a moment, looking at it. Then she answered. "Naomi." His voice was its usual register, measured, slightly careful, with the specific politeness of a man who was capable of warmth, but chose to deploy it strategically. "Roland, I thought we should talk before this goes further." "All right." He was quiet for a moment. She could hear in the background the sound of a room, probably his hotel suite in Savannah. She had been told he had checked in for the week. "I'm not doing this to hurt you." She said nothing. "I'm doing this because Mother's wishes should be respected." "Geraldine's wishes," she said. are written in an amendment that was filed with the trust in 2001. You were at her house that year, Roland. You know about the amendment. The silence that followed was a different kind of silence. That document, he began, is certified and has been filed with the court. Another silence. Haverfield is reviewing it, he said finally. I imagine he is. She heard him shift. The quality of the air in the call had changed. Something had gone out of it that had been there at the beginning. There may be room to discuss a resolution here, he said, outside of court. I'm open to conversation, she said. I have always been open to conversation with family. You chose to skip that step. He cleared his throat. There's a version of this where you stay in the house. I'm not trying to put you on the street. I know you're not, she said. You're trying to put your name on the deed. Quiet. That's what this is about, she continued evenly. It's not about Mother's wishes. Geraldine was clear about her wishes. It's about the fact that you have always felt this house should have come to you, and Edmund's death gave you what looked like a window. That's not Roland. Her voice did not rise. It did not sharpen. It simply became more present, the way a room becomes more present when someone lights a lamp in it. I am not angry with you. I want you to hear that. I'm not angry, but I am not going to settle. I'm not going to agree to any arrangement that treats this house as something up for negotiation. I live here. I have lived here for 31 years. I raised 4 children in this house. I kept it through a hurricane, through Edmund's illness, through his death, through a pandemic. I paid every tax. I maintained every board and beam. The amendment is in the record. We will see you in court. She heard him breathing. I hope, she said, that Haverfield gives you a realistic assessment of where this case now stands. Then she said, Good evening, Roland, and hung up. She set the phone on the kitchen table. She stood at the window for a moment. Then she poured herself a glass of water, drank half of it, and went to call Audrey. The preliminary hearing was scheduled for a Thursday morning in October at the Chatham County Courthouse on Montgomery Street. Naomi had been in courtrooms before, as a witness, as a juror once, years ago. She understood the grammar of them, the formality, the specific tedium, the way time moved differently inside those high-ceilinged rooms. She dressed that morning with the deliberateness of a woman who understood that appearance is a form of communication, not vanity, not performance, communication. She wore a deep charcoal suit she had bought years ago for a school board presentation and had always felt most like herself in. Her hair was natural, neat, pulled back from her face in a way that was clean and graceful. She wore her late mother's pearl earrings. She wore low heels, comfortable enough for standing. She looked at herself in the mirror for a moment before she left the bedroom. She thought of Geraldine. She thought of Edmund in his Sunday chair on the back porch. She thought of the kitchen table and the 4 voices that had sat around it when they were small, the arguments and the laughter and the ordinary chaos of a family that was becoming itself. She picked up her coat. She went downstairs. Pearl was in the kitchen. She had made coffee and left it on the warmer. She did not say anything when Naomi came in. She simply handed her a travel cup and held her gaze for a moment with the calm composure of a woman who had done her part and trusted the rest to others. All 4 children were at the courthouse when Naomi arrived. Simone was already in conversation with Audrey, gesturing with her hands in the controlled, emphatic way she argued when she cared about something. Marcus was standing to the side of the courthouse steps reviewing his phone, professional habit. Darius stood near the bottom of the steps, hands in his pockets, looking at the street, his presence quiet and complete. Celeste, in a neat blazer she had borrowed from Simone, stood next to Audrey and was listening carefully to everything. Roland arrived 5 minutes later. He was with Haverfield, who was a compact, sandy-haired man in his late 50s who moved with the confidence of a person who won most of what he argued. He did not look at Naomi. Roland did, for just a moment. And something in his expression, something that was not cruelty and not triumph, but might have been the shadow of something more complicated, something like regret that had arrived too late to change anything, crossed his face before he composed it again. They went inside. The hearing lasted 2 hours and 40 minutes. Audrey argued the amendment clearly and precisely. She presented the certified copy. She walked the judge through the language of the 2001 modification and explained exactly why, under its terms, the secondary beneficiary clause had not been triggered by Edmund's death. Haverfield argued that the amendment was a supplemental document of uncertain authority, that it had not been formally incorporated into the trust through standard legal procedure, and that its language was ambiguous on several points. The judge, a measured woman in her 60s, whose courtroom manner suggested she had no interest in theater and every interest in accuracy, asked several careful questions of both parties. She asked Haverfield specifically whether he had been aware of the 2001 amendment prior to filing the original petition. Haverfield said he had become aware of it in the days following the respondent's supplemental filing. The judge looked at him for a moment, just a moment. Then she said she would issue a preliminary ruling within 10 business days. They waited. Naomi went back to her routines. She returned to her part-time consulting work for the school district. She cooked dinner. She walked the neighborhood in the early evenings when the heat had finally relented and the oaks on Abercorn Street were turning and the Spanish moss moved in the afternoon light like something breathing. Pearl saw her on one of these walks, coming back along the side of the house, and fell into step beside her without being asked. They walked for a while without speaking. Then Naomi said, "When you were in Columbus, before you came here, were you all right?" Pearl considered the question. "I was upright," she said finally, which, at the time, was the best I could say. Naomi nodded slowly. "You gave me a quiet place to be," Pearl said. "The carriage house, the work here. It let me get my bearings again." She paused. "I don't take that for granted." Naomi was quiet for a moment. "Edmund would have liked you," she said. "He had a way of knowing which people were steady." They walked on. The porch swing creaked lightly as they passed. The ruling came on a Tuesday. Audrey called before 9 in the morning. Naomi was in the kitchen with her coffee when the phone rang. "The judge found in your favor on the standing question," Audrey said. "She ruled that the 2001 amendment is a valid modification of the trust instrument, and that under its terms, Roland Calhoun's secondary beneficiary designation did not activate upon Edmund's death because Edmund had surviving issue." A pause. She dismissed Roland's petition. Naomi set down her coffee mug. "There will likely be a challenge," Audrey continued. "Haverfield will probably advise Roland to appeal, but the grounds for appeal are narrow, and frankly, the judge's language in the ruling makes it fairly inhospitable terrain." Naomi stood very still. "Naomi," Audrey said gently, "the house is yours." Outside the kitchen window, the morning light was doing its October thing, coming through the glass at that particular angle, filling the room with something warm and golden and exact. The cast-iron skillet hung on the wall. Edmund's photograph was on the windowsill. "Thank you, Audrey," Naomi said. Her voice was steady, completely steady. She hung up. She stood at the kitchen table for a long moment. Then she sat down, slowly, in the chair she always sat in, the one that faced the window, the one that had a slight gouge in the armrest from the time Marcus, at age 7, had dragged it across a concrete step, and she put her face in her hands, not in grief, not in relief exactly, in something harder to name. In the full weight of it, the 31 years, and Edmund's letter he never sent, and Geraldine's careful cursive, and Pearl in the archive room with a scanner, and her children around the table, and every tax payment and maintenance call, and hurricane board-up, and Sunday dinner, and 2 a.m. moment of wondering if she was holding all of it together, and the answer, now, confirmed. She was. She had been. She sat like that for a few minutes, her face in her hands, in the morning light. Then she lifted her head, wiped her eyes with the back of her hand, and picked up her phone. She called Darius first. Roland did not appeal. Haverfield, according to information that reached Audrey through professional channels some weeks later, had advised against it. The amendment's language was clear enough, and the judge's ruling specific enough, that an appeal carried significant risk and minimal likelihood of a different outcome. Roland drove back to Atlanta in his silver sedan. He did not call. He did not write. There was a cousin, Diane, who was close with both families and had served as an informal intermediary for years, who reached out to Naomi 3 weeks after the ruling. Diane was careful and kind in the way that people are careful and kind when they are trying to navigate something painful without taking sides. "He's not at peace with it," Diane told Naomi over the phone. "I know," Naomi said. "He really did believe it should have been his. I know that too." Diane was quiet for a moment. Is there any version of a conversation down the road?" Naomi thought about this honestly, the way she thought about difficult things, not refusing them, not rushing to resolve them, but letting them sit until she understood their real shape. "Someday," she said finally. "Not now, but someday, I think I could sit across from him and speak plainly. I don't have hatred for him, Diane. He made choices I can't respect, but I understand what drove him. Pride and old wounds are powerful engines." A pause. "But understanding is not the same as forgetting. He came to my door and handed me that envelope like I was a stranger on the street. I know. I am not in a hurry to heal that." "That's fair," Diane said quietly. They stayed on the phone a little while longer, talking about easier things. Diane's grandchildren, the October weather, the church fall fundraiser, the ordinary fabric of lives continuing. 3 years passed. Not quickly, the way time passes in stories. Slowly, the way it actually passes, with seasons and setbacks and unexpected small graces. The equity line was paid off the following spring. Naomi had put a portion of her savings toward it, and Marcus had offered to contribute. She had let him, not easily but genuinely, understanding that sometimes allowing your children to help you is its own form of mothering. The title was clear. The deed was hers. Audrey Simmons Holt retired from her Savannah practice at the end of that year and moved to the Georgia coast. Before she left, she framed a copy of the judge's ruling, the specific paragraph about the 2001 amendment and Edmund's surviving issue, and sent it to Naomi with a note that said, simply, "For the record." It hung in Naomi's study, above the desk where she had sat in the lamplight reading Edmund's unfinished letter, above the filing boxes that had held 30 years of their life in paper. Pearl was still in the carriage house. She had taken a part-time position with a Savannah estate law firm, legitimate, paid employment, drawing on exactly the skills she had been using informally for years. She drove a newer car. She cooked on Sunday evenings and sometimes brought leftovers to the main house and left them on the back porch, and Naomi always texted back a single word, delicious. It was not a grand friendship. It was the quieter kind, the kind that persists because it was built on something real. Marcus came back to Savannah at Christmas each year and stood in the front yard for a moment, looking at the house the way he always did. He had softened slightly in the years after the case, not lost his precision. He was still Marcus, still the pragmatist, still the man who called with action items rather than comfort. But he had started arriving a day earlier than he used to, staying an extra morning before driving back. Small things. Simone had been hired by a legal advocacy organization in Atlanta that worked on housing rights cases. She was formidably effective at her work, her combination of rage and intelligence and inherited discipline proving, in a professional context, close to unstoppable. She called her mother every Sunday. She never said what the case had done to her internally, but she had stopped keeping Roland's name in her mouth. That specific silence said more than words. Darius was steady. Steadier than he had been in years. He had joined a small book club at the library where he worked, and he had started writing again, not for publication, just for himself, in a spiral notebook he kept at his desk. He did not talk about what he wrote, but Naomi had seen him, once, writing at the kitchen table on a Sunday afternoon, and the expression on his face had been one she had not seen there in a long time. Something like peace, something like presence. Celeste graduated from law school in May of the following year. Naomi drove to Atlanta for the ceremony and sat in the audience in her charcoal suit and Edmund's mother's pearls. And when Celeste walked across the stage, she rose to her feet and clapped in a way that drew a few looks from the people around her, and she did not care at all. Edmund would have wept. She wept a little quietly when she was back in the car alone. The thing about legacies, the real thing, not the word as it appears in legal documents and trust instruments and probate filings, is that they are made of accumulated time, of days, of presence, of the small daily decisions to show up, to maintain, to pay the taxes and paint the shutters and replace the porch boards and plant the tree, of the unspectacular, invisible, lifelong work of caring for something. Roland Calhoun had wanted the house as a symbol, as proof of something, as the resolution of a wound that went back decades, to a boyhood in which he had watched Edmund receive things, their mother's attention, the family name, the property, that he had believed should have been shared more equally. His wound was real. His grievance, in some distant original form, was human, but he had carried it forward into the wrong kind of action. He had tried to take from a living woman what a dead woman had worked to protect. And Geraldine Price, careful, precise Geraldine, who had written her amendment in longhand in 2001 and filed it quietly in the supplemental annex, who had never made a speech about it, who had simply done the procedural, permanent thing, had been waiting, in ink and notary stamp, for exactly this. The dead protect the living sometimes, not through miracles, through documents, through the foresight to put the right language in the right place at the right time. Naomi understood this. She had understood it the moment she read the amendment in the archive room, standing beside Pearl in the afternoon quiet. She had felt Geraldine in the room with her. Not mystically, just the way you feel the presence of someone's intentions laid out plainly on paper. She was saying, "I saw this coming. I tried to be ready." She had been. On the second Saturday in October, 3 years after the ruling, Naomi Calhoun Price held a gathering. Not a party, not quite a celebration. Something harder to name than either of those. She had invited the people who had been present during the preceding months, who had stood in her kitchen and around her table, and in courtrooms and archive rooms, and on her back porch in the evening quiet. Her children and their partners. Audrey Simmons Holt, who drove up from the coast. Pearl, who came in from the carriage house. A few neighbors who had lived on the street long enough to know the history of the Price house and the family inside it. Diane, the cousin, who arrived bearing a pie, and the quietly grateful expression of someone who had been afraid of a permanent rift and had been relieved to find it had not arrived. The weather that day was extraordinary, the way Savannah Octobers can be when they choose to be. Warm enough for the porch, cool enough for a sweater, the light coming through the live oaks at an angle that made everything look older and more significant than it was. They ate on the back porch and in the yard. Darius had made his grandmother's sweet potato dish from memory. Celeste brought wine. Marcus, who had arrived the night before and stayed in his old bedroom, made coffee in the kitchen the way he had watched his mother make it for 30 years. Exactly. Pearl stood at the edge of the yard with a plate, talking to Diane, and the conversation looked comfortable, easy, the way conversations look between people who have arrived, through different routes, at a common sense of what matters. Naomi moved through the gathering the way she moved through rooms, not urgently, not performing, just present, stopping to speak with each person, laughing at something Simone said with a sharpness that made 3 people nearby turn toward the sound of it, holding a neighbor's baby for a moment, looking at the small face with an expression that was tender and private. Late in the afternoon, she was alone for a moment on the front porch. She could hear the gathering behind her, voices and laughter, the particular music of her people in her house. She could hear the street in front of her, a car going by, the sound of someone else's child on a bicycle, the distant bells of a church 2 blocks away. She looked at the 2 live oaks. She looked at the magnolia tree she had planted in the side yard 26 years ago, now taller than the porch roof. She thought of the day she and Edmund had stood in this yard after Geraldine's funeral, when Edmund had said quietly, looking at the house, "I want to make sure we always take care of it." And she had taken his hand. She had kept that promise. The cost had been real. The $10,000, the weeks of tension, the 30 days of a clock running while her family gathered and worked and held on. The knowledge that Roland was in Atlanta now and that they would not, likely, ever be what families are supposed to be to each other. The ongoing quiet of that particular loss, not the legal fight, but the original loss, which was the loss of any hope that he had seen her as real. The cost was real. She did not minimize it, but she was standing on this porch. The house was behind her, full of people she loved. The deed was in her name. The cast-iron skillet was on the wall. She put her hand on the porch railing, the one she had painted herself in the spring, a clean, crisp white, and let the warmth of the afternoon wood come through her palm. She stayed like that for a moment. Then Darius opened the screen door and leaned out. "Mama, Celeste is about to make a toast." "I'm coming," she said. She took her hand off the railing. She went inside. The Price house stands today on its corner lot on Abercorn Street in Savannah, Georgia, under the 2 live oaks that have been there longer than any living person can account for. Its shutters are painted a deep green that Naomi chose the summer after the ruling, standing in the hardware store for 20 minutes with paint chips in her hand until she found the one that looked exactly right. The magnolia tree in the side yard blooms every May. The carriage house is still rented. Every Sunday evening, if you happen to walk by, you might see the light in the kitchen window. You might hear voices, not always 4 of them, not always loud, sometimes just one, sometimes the low murmur of 2 people at a table with coffee. You might not think anything of it. That is exactly the point. What looks like an ordinary house on an ordinary street is the accumulated proof of a woman's life, the evidence that she was here, that she held on, that she did the paperwork and paid the taxes and showed up in the archive room and stood in the courtroom and spoke plainly to the man at the door, that she built something that a legal instrument from 1997, a modification from 2001, and 31 years of daily presence made impossible to take. Not glamorous, not a victory with fireworks, just permanent, just hers. If this story touched your heart, subscribe now, hit like, and tell me in the comments what city you're watching from. It helps us keep sharing stories about strong women, families, and life's unexpected turns. Remember, this is a dramatized fictional story for entertainment only. It does not provide legal, medical, or financial advice. Viewer discretion is advised. See you in the next video.